Changing by July 1st. So please take this information with a grain of salt. Okay, well, good afternoon, and thank you, Center 21 Masters, for having me here today, for the invitation and having me share these great tools with your realtors. My name is Paulina Martiñón, and I've been doing evictions for 17 years, believe it or not. I am not an attorney. I am, however, a UDA licensed paralegal. What does that mean? That means I am actually licensed by the state to perform evictions. Our office is attorney supported, meaning that if you have to go through an eviction, you need trial, you need a jury, we do have the attorney support. Our attorneys only handle evictions, so the information that will be relating today will be landlord-tenant related only. I want to confirm, how much time do I have today?
Whenever you're done.
Okay, so I'm gonna
usually I mean, after an hour, people tend to start drawing off. So 45 minutes to an hour would be perfect.
Perfect. So I'm gonna go straight with information and slides. That should take about 20 to 25 minutes, and I'll open up the rest of the time for Q&A. So please write down your questions so you don't forget. Also, you could put them on the chat. I'll have Miss Cindy read that for me at the end, and then I'll answer. Or you could always unmute yourself and ask towards the end of the presentation. So I'll make sure to leave enough time. Now, my objective today is to provide clarity in the layered eviction moratorium rules that we have going on right now. And hopefully I could do that in a digestible manner. Now, I must warn everyone, information is constantly changing. And the purpose of this webinar is to touch surface of what's going on, give you a foundation, but please make sure you consult with the professional if you have any specific scenarios. So without further ado, I'm gonna do my screen share and I'm gonna get straight to our presentation. So as you can see, we have a vast enough of team members in our office. It's not just me. I actually do not do consulting appointments. The consulting appointments are handled by our case managers. I do, however, deal with presentations, and memberships. We do have a membership program. Talk about that later. We are experienced in evictions. This means layered rent control. What's layered rent control? I'm going to explain, but pretty much we have about 26 different types of rent control rules in LA County itself. We also deal with REAP properties and situation. If you don't know what's REAP, that's good. You want to keep it that way. You don't want to find out what REAP is. And of course, we work with Section 8 tenancies. This is the agenda, latest news, rent relief, rent increases, getting your files ready, our fee schedule, and of course, Q&A. So in order for me to really explain what type of, I'm going to discuss state rent control and county rent control. I'm barely going to touch through some city rules. So to give you an idea, this is what I mean when I say layered rent control. We have federal rules, and federal rules normally only apply to Section 8 tenancies. Then we have state rent control, which came into effect January 1st, 2020. Ever since then, 90% of rentals in California have some sort of protection. And then we have county, which is a temporary moratorium that we're dealing with until at least next year. And then we have individual city rent controls such as Los Angeles, Santa Monica, Pasadena, Culver City, Hollywood, Glendale, Burbank, unincorporated areas. And to give you an idea, it's 28 different set of rules. This is why if any of you ask me, could I evict? My answer to everything will always be, it depends. It depends on what type of rent control rules you have to see what we have to follow. There's no such thing as a yes or no, and there's no such thing as a quick answer. At the end of this, if you guys have any specific questions, I need to, at the bare minimum, know property address, number of units on the lot to give you a general idea of the answer. Clear? Okay, so rent increases, let's get that one out of the way, is the easiest. The rent increases really depend by area. If we're talking about state rent control never froze increases. They change. And the increase changes every May and every September of every year. And it's the 5% base plus local CPI. The CPI is what fluctuates and gets recalculated every May and every September. So right now, until next month, we are at 8.6% total for each county: San Bernardino, Riverside, LA, and Orange. Now, if the only two areas that have frozen rent increases is LA City rent controlled units and unincorporated rent control units. So if your property is subject to LA City rent control or unincorporated rent control, rent increases have been frozen since March 2020 and will continue to be frozen until next year, 2024. Now, not every property that's in LA City or unincorporated LA is subject to rent control. There are exceptions to rent increases. So in order for you to properly identify your governing law, you could always request with our team a property research. Our fee is $75 for that report. It's about 2 to 3 pages, and it's going to give you all the information that you need to know regarding the property, how much you could increase, if you could evict, so on and so forth. Okay, moving on to the next slide.
Where do you get that? I'm sorry. Where do you get the, you mentioned that you can pay for a few dollars for it. Where do you get that from? Is it for every city?
If you're asking how you could request that from our office, you could email our team at
Oh, I see.
evictions.com.
Thank you.
Not a problem. Thank you. Okay, next slide. Allowable evictions. So I'm going to start off with outside LA County because it's the easiest. LA County is a problem child, so we leave that towards the end. We have Riverside, Orange, and San Bernardino counties that have been back to normal since October 2021, meaning that in these areas, evictions for landlord occupancy, for non-payment of rent, for substantial rehab, for breach, illegal activity, anything has been back on the table since October 2021. Now, of course, what varies is the type of notice and the reason, depending if you're subject to state rent control or no rent control. So for a consulting appointment and to make sure that you're in the right track to prepare the right paperwork on an eviction, you always want to consult a professional. My famous saying is, do not do your own divorce, do not do your own taxes, do not do your own Botox, do not do your own eviction notices. Always make sure that a professional is doing this. Otherwise, especially in California, we're a lawsuit country, a lawsuit state, you will be walking yourself into a wrongful eviction. And those are costing agents about $150,000. Because if the agent is the one who prepared the notice, at the end of the day, there's always someone to blame. And if your insurance doesn't cover that lawsuit, that's the average payout price on a wrongful eviction lawsuit. Okay, now if you're inside LA County, we have a whole different story. Why? Because the board of directors of Los Angeles County do believe strongly that evictions shouldn't continue at least until 2024. Now, there has been changes, and there's always changes. These changes were released last month. So the changes that we have, and some of the changes are from the beginning of the year, so I want to make sure you guys are aware of those changes, and this is why I have them on this slide. So as of January 31st, which is really February 1st, commercial protections have expired, meaning that if you have a tenant that is in a commercial property and it's not paying the rent, they no longer have the protections. You may pursue with enforcement of those rents or segue into an eviction if needed. If that commercial lease has expired, the landlords could start a 30-day notice, or depending on what the rental agreement states. It's not a general, it's not a one size fits all. It always comes down to what it's written in the rental agreement and what is written in the law. So please take that into consideration. Number 2, evictions based on refusal of entry will be back on the table after July 1st, 2022. So all those showings that did not go through, or all those properties where they had to get pulled off the market because the tenant was not cooperating in even getting a home inspector in, it's now back as an eviction reason starting July 1st, 2022. Now, rents are currently not protected thanks to Assembly Bill 2179. So we're calling this our golden period. Any rents that are not being paid from April, May, or June could begin eviction. So as you could imagine, we're bombarded with calls and work right now for evictions because LA County landowners, this is their only opportunity before LA County could resume their rent protection period. And once LA County resumes that period, it will resume in July 1st through the end of the year. They are thinking about extending it through 2023, meaning that if a tenant does self-certification that they could not pay the rent, we're not going to be able to proceed with an eviction if that tenant actually issues that self-certification to the landlord. Now, evictions for nuisance, unauthorized occupants, or pets, if it's necessitated or related to COVID-19, are also going to be frozen and are until the end of the year. Now, evictions for honor occupancy may be allowed if the unit is a triplex or under, single family dwelling, condo, mobile home, duplex, or triplex. So anything above that does not qualify. And the tenant needs to be up to date with the rent, and the landlord needs to be similar situated as the tenant. At that point, a 60-day notice could be issued along with relocation fees. Relocation fees, currently the LA County fees apply, so that could be up to $20K. It really depends on the scenario. Now, unfortunately, these rules are across the board to any and all residential properties inside LA County, regardless if it's a single family dwelling, regardless if it's exempt from rent control. Right now, LA County pretty much, in the name of a local emergency, is dictating what a landlord could and could not do with their rentals until the end of the year. Now, AB 2179, this got rolled out on August 1st, 2022. It's in effect until June 30th, 3 months. So what does this bill mean? What pretty much protects tenants who have active rent relief applications pending, under review, or in process. Now, it does not protect tenants whose rent relief applications are inactive or denied. Now, it does not protect rents after March 2022, meaning that if you have a tenant that has not paid rent in the last 2 years, and believe me, we see plenty of those right now, if their application is inactive or denied, an eviction is on the table. If they did not pay April, an eviction is on the table. Now, the only reason a landlord cannot evict is if the tenant is paying April and the rent relief application is in process. So those type of tenancies have the protection of 2179 to avoid eviction until the rent relief application gets paid out by the government. Now, the rent relief will cover up to 18 months or March 31, 2022. Also, it does preemptive local moratoria with the exception of LA City, Pasadena, and Beverly Hills. Okay. Now we have mandatory rent registries. So these are some of the cities that require landlords to register the property as rentals and to pay a fee. If a landlord does not register the property and does not pay a fee, they have no right to evict. So we have unincorporated rent control. We have LA City, Inglewood, Baldwin Park, West Hollywood, Beverly Hills, Culver City, and Pasadena City. Now, getting ready for an eviction case. This is pretty much your to-do list if this is what you need to endeavor in. So 1, issue governmental law disclosure. What does that mean? That means you need to notify your tenant what type of rent control rules their property is subject to. And remember, one size does not fit all. Number 2, you must issue state and local COVID mandated notices. Number 3, you must ensure that an attorney cap is in place. Also review that rent increases are up to date and they've been legal up to date. So just to give you an example, we've had clients lose an eviction because they did an improper or invalid rent increase back in 1996. This is an eviction law. What you do, if what you did in your past will eventually come back to hurt your case. Now, if we're evicting for non-payment of rent for rents prior to March, we do need a rent relief denial letter or an inactive letter. Your documentation and timeline must be in order, and property must be in good condition or habitable. This is a big one. California passed a bill at the beginning of this year that a landlord cannot evict if the property is not in good condition. So if the landlord says, well, the tenant has not asked for repairs, that is no longer an excuse. A landlord must inspect the property every 6 months to ensure that the property is up to date. Okay. Now you always want to discuss your eviction strategy with your attorney or legal office. Now, eviction overview. These are the approximate steps. Every case is very different. Some cases need double the steps. If there's motions, demurs, discovery, we have to remember an eviction is a legal battle. So back in the day, it was very transactional because tenants did not have free attorneys. Tenants now have free attorneys, so it's no longer transactional. Now there's discovery involved, there's depositions involved, there is oppositions. As such, since back in the day, and back in the day is prior to 2018, an eviction could be done in 3 months, 2 months. Really, it was a timeline and getting all the paperwork in. Now, if there's a defense attorney on the other side, we have to go through a legal civil litigation case. And an average civil litigation case takes about 6 months. Now, if your eviction is outside LA County, chances are we're going to be done with that in about 3 to 4 months because those counties do not offer the volume of free attorneys as LA County does. Now, any eviction filed in LA County, tenants automatically have the right to a free attorney, kind of like in a criminal situation. As such, we do see an increased time frame due to the litigation that's involved, and of course, fees. An eviction is not $800 from start to finish like it once was. Now we're talking about thousands, depending on how much work goes into this case. Now, every eviction starts with a legal notice. That is the most crucial step. That's our foundation to the eviction. Second step is the actual lawsuit. Third step is a court date if the tenants file an answer. Now, fourth step may be jury trial if the tenants obtain free legal representation. And finally, the last step that everybody aims for is the sheriff. And the sheriff step could only happen once a judgment or a stipulation is reached. Okay. Now, I think I have like 2 more slides and then I could go to Q&A. I'm trying to go through the information as much as possible so I could get through questions. Now, agents' do's and don'ts. You want to make sure that you're informed of the rules and regulations of a property before informing your client. The worst thing that you could do is tell your buyer, oh, don't worry, once you buy the property, you could evict them, or you could increase the rent. And then they come to me and I have to give them the truth, then you don't look so good. You want to make sure your credibility is intact, and by informing yourself or informing your client. Unfortunately, now it's a cost of doing business, making sure that all the information is in place correctly. Now, agent, if you're representing the seller, do not promise the property vacant, especially in escrow instructions. You will get sued if you realize you cannot evict, but you promised it and now escrow is closed. Do verify that the correct legal notices are in place. Do not prepare your own notice. Now, if you're representing the buyer, do not tell your client that they could increase rent upon purchase unless you have verified. Also, you want to make sure you're protecting your client by requesting a tenant estoppel certificate and a rent roll at the very least. You also want to get rental agreements. You want to get whatever documentation. You pretty much are inheriting a tenant. You are inheriting to whatever history the previous landlord did or didn't do. So you want to make sure your client has the whole file of what's going on with that tenancy. Just remember, having the right paperwork protects your rights. Okay. Now, basic fees. Landlord consulting services start at $150 per half an hour. So pretty much our job is to verify everything, make sure that the history of the rent increases was done correctly, that the rental agreement is up to date. If not, we need to put a plan together of the notices and the addendums that a case needs. If you want the appointment directly with the attorney, it's $250, but trust me, we're the ones who do the work anyway. Legal notice bundles start at $250, and we make everything meaty. We make sure that your notice, your case has the foundation it needs. It's no longer just a 60-day. It's no longer just a 3-day. When I see just a 60-day or a 3-day, I know that person does not know what they're doing, and it's only a matter of time before it falls through. Now, we do have monthly retainer memberships available. That's $195 a month. That includes unlimited consulting, unlimited case review. We do have a monthly webinars where I give information. We go through Q&A, a monthly news member alerts. So I make sure my membership clients are constantly informed, and we're pretty much retained to answer their emails or their calls or questions, and a monthly fee. We, of course, prepare rental agreements. We do rent control research. Eviction bundle pricing, we start at $1,500, and that pretty much includes most of the paperwork you're gonna need, the court filing fees, the process server, the babysitting the case, pretty much managing the case and doing all the paperwork from start to finish. Attorney court appearance, we still charge flat sessions. We don't charge hourly. So we're at $450 flat. I'm gonna end with that because I know that there's Q&A. So now I'm gonna invite Cindy to read any questions that we may have. first on the chat, and then we could, whoever has questions that we would like to ask directly, you could raise your hand and we could go ahead and ask to unmute you.
Okay, well, first of all, I have a question. And it's many people have asked me and I don't know the answer to this. Is if the land, if we're in escrow to sell a property and the owner gives a 30 or 60-day notice, which will not end until after the property is sold. So we sell the property in the middle of the 60-day notice. Can the new owner piggyback on that notice, or do they have to serve a whole new notice?
90% of the time, the answer is going to be no. The landlord can no longer piggyback because most properties are now subject to state rent control. So state rent control requires that the person that's going to move into the property is the person on title. So if the seller starts the eviction, then by the time we start the, by the time the buyer continues with that, there's been a title switch. As such, the eviction is no longer good. Now, that wasn't always the case. Back before 2020, we were able to do that. Not anymore. After 2020, the game has changed.
Oh, good to know. Okay, there is one question in the chat, and I've had that, and I know more than one agent has this going on right now. So generally, you have a property where a family member is living. There's no lease, there's no rent. The family member was just living there, but now you're selling it, and they won't leave. Can you get them out?
Depends. My answer is always going to be it depends. The first question is going to be, are they on title? Were they ever on title? Is there a trust? Are there beneficiaries to the trust? Depending on those answers is what we could do. If they are beneficiaries to a trust or they're on title, we have to wait until that gets disbursed. And we have an order most of the time from an attorney or a judge saying that we could proceed, that the beneficiary is going to get their proceeds of the sale. And at that point, we could continue depending if this person ever paid rent or not. So sometimes we have beneficiaries that still do pay a monthly fee to reside in the premises, and sometimes we don't. So depending on those reasons, it's going to be if we could actually pursue with an eviction or not.
Okay, also, thank you. I hope that answered the question. I'm also in a single family home in Orange County. Can they raise, is there a maximum they can raise their rent?
It depends. What's my favorite legal answer?
It depends, yep.
Depends. So it depends on if the exemption form was issued by August 2020. The exemption is that, hey, tenant, I'm exempt from rent control. My property is not subject to rent control. If that exemption was issued, then you have zero rent control and you could increase to whatever you want. However, due to the fact that we're under still a state of emergency, we are capped under the anti-price gouging rules and rents. You cannot go above 10% for the time being. Once the state of emergency gets eliminated, which we're expecting that to happen this summer, then you could once again increase your rent to a higher amount if desired. So as long as the proper notice is issued. Now, if the state mandated exemption form was not issued, you're subject to state regulations, which would be the 8.6%. In order for you to verify, we need to review the rental agreement and make sure that that exemption was in place.
Hello, Paulina. Nice to see you here with Masters.
Hello.
I have a quick question. In Orange County, the rent control applies on single-family residents?
Yeah, so rent control, state rent control came into play January 1st, 2020, and it's all of California soil, whether you're in Orange County, Riverside, San Bernardino, Alameda County, San Bernardino, pretty much all of California. The exemption was supposed to be issued by August 2020. If that exemption wasn't issued, any other way to get exempt out is to update your rental agreement.
Meaning you can do an addendum to the leasing agreement? I mean, to the leasing agreement?
You would have to update your rental agreement with the exemption, exercising your exemption.
The prices you quoted.
Okay, once you exercise that exemption, the tenant must sign. If the tenant doesn't sign, you're not exempt.
What did you say? If the tenant doesn't sign what?
You're not exempt.
Oh, right, they have to sign. Okay.
Correct. So pretty much the tenant needs to sign a new agreement. If the tenant does not sign a new agreement, you're subject to the state rules. The reason being is because that's what the verbiage now is on that bill, that the landlord only had 8 months to freely exercise without the tenant having to agree. After August 2020, the tenant has to agree.
Paulina, I have a quick question. For my rentals, I usually collect 2 months, the equivalent of 2 months for the deposit. I've noticed that as this moratorium, I mean, I'm in LA County, so I'm thinking, is there a possibility I can collect more? I don't care if I condense the pool of applicants, but I would like to collect more for the deposit.
The answer to that question is simply no. California does not allow to collect more than 2 times the amount of rent on a security deposit unless it's a furnished home. Then you could go up to 3 times the amount. And if you are renting to a military tenant, it's one security deposit amount. So if the rent is $2,000, then you could only collect $2,000 for security deposit.
So
If
for
it's not military, then you could collect, for example, $4,000. If the home is furnished with actual furniture like a bed and sofas, then you could collect up to 3 times.
I see.
Okay.
Oh, it's interesting. It's interesting how they impose their own rules, but they don't allow us to come back and say, well, then we need to collect more for any damages. But interesting. Thank you.
100%, and every state is different. So California, this is California for us.
I also want to piggyback on something that has been said. I'm pretty sure, we haven't tested it yet, but I'm pretty sure that our E&O insurance will not represent you for serving a 3-day notice. Or a 60-day notice. If you prepare and serve a notice, that is legal work, and we are not covered under our E&O insurance for that. So please be really careful, because if you don't have insurance, it means you're paying for if someone sues, you're paying for your defense. So just when you think about and you have questions on what notice do I serve and what do I do, guess what, guys? If you serve those notices and you get sued, you're not going to be insured. So just keep that in mind.
Don't do your own legal work for sure.
Excuse me, I got a question. When you said about the signing the exemption, the tenant and the landlord, what is the interest? Let's say that I buy a property and I want to sign the exemption and I want the tenant to sign it, so that way I can increase without the rent control. What will be the interest on the tenant? The tenant know if he doesn't sign, the limit is 8.6. The moment they sign, he can go higher.
It's not to the tenant's interest at all. Correct.
So we send them the form, but if they don't sign it, that means we are subject to 8.6 only, correct?
Correct. And the 8.6, I repeat, Michael, it is not a fixed rate. All this information is fluid. That changes, and it will change next month. Now, most landlords, if you come with me, I tell you how to get those contracts signed. So I don't give away all my tricks, because otherwise I would be on unemployment. But
now,
if you need direct consulting, you could always call our team.
Okay, now when you say 8.6 that is paying twice a year, that means you pay 4.3 and one part, and then 4.3 the second part, right? You can increase it twice.
No.
You're assuming right there. So it's a total of 8.6. You could only increase 1 time per year.
So in other words, only 8.6 either is the first part, or if you didn't do it, the second part then, right?
Correct.
I see.
Now, I'll have a question here that I'm gonna go back to the chat for the people that did put
I
their
was
question
trying.
here. So I have Nina Kerman. Does tenant relocation fees apply to outside LA County only? Will this also apply to single family dwellings? So Nina, and this is for everyone, good question. Relocation fees apply, period. If you're subject to state rent control, you could be in LA County, Riverside County, Orange County, San Diego County, you may be subject to relocation fees. It's not an automatic. It comes down to, once again, what your property is subject to in governing laws. So if you don't get anything from this webinar, the main thing for you to know is there's not a one size fits all. You're not gonna get a quick answer out of a general question. And the reason is, I have to ask, what's the full property address? How many units on the lot? When was the property built? Depending on the layer of all the answers to those questions, I'm gonna know what rules you must follow. So if you ask me, Nina, that question, and it's in a single family dwelling in San Diego, well, guess what? You're gonna have to pay probably up to $10,000 in relocation fees. But if you're asking me that question in a property in San Bernardino, you're probably gonna pay only 1 month of relocation. Now, if you ask me that question in unincorporated area of LA, the answer is gonna be up to 28,000. So the answer varies in a lot of factors, okay? Next question I see here. Yvonne Rosas, not on title, not in trust. I'm assuming that's your follow-up answer to your first question regarding the 5301 Huntington Drive. That property is subject to LA City area. I would have to verify the rental agreement in order to answer your question. So you definitely need a consulting appointment.
It was no rental agreement.
There's no rental agreement. Was the tenant supposed to pay any rents?
This is
It
the
says in
one
there,
that's
no.
a family member. It's a family member who was
But
just
was
staying.
the family member paying a monthly fee of any kind? Was there
No.
exchange of money?
No, they were just allowed to stay there because it was told it was gonna go for sale. He said he'd
How
stay
long
there
were they
and make
staying
sure it
there
was
for?
okay. About a year.
So then it's probably gonna be a 60-day notice, no landlord-tenant relationship, which is under Civil Code Section 789, meaning that it's not your traditional 60-day. Along with notice of exemption. Okay, moving on to Mr. Mike Doyle. I own a detached single-family home in Orange County. Do I have a maximum I can raise? Mike, depending if you issued your exemption or not. If you issued your exemption, you're at 10%. If you did not, you are at 8.6% until next month. Next month, May, middle of May, these percentages change. Okay. George, rent registry for Pasadena, if property single family dwelling, does it still need to apply? George, no, it does not. Pasadena registration is for 2+ units. Are we good to offer reload to the tenants as an agent in LA County area? That would be a question for your office. I know some offices do not allow their agents to get involved with relocation conversations. Some offices do not mind. In on my end, it doesn't matter who creates that agreement with the tenant. We just put it in writing to make sure that it goes through. Okay, so that's an answer you would have to ask your broker. A question, I'm sorry. Okay, Mr. Santos, is a contract renewal optional, or do we need any specific legal matter to ask them to move? It depends on the area. Some areas, even if you have a yearly lease, tenants are protected against landlords asking them to vacate. Example, if you're in LA City or ULA, it doesn't matter if your lease expired. You cannot ask a tenant to vacate unless you have the qualifications to ask. If you're in state rent control, the same thing. You have to follow the state rules in order to ask a tenant to vacate the property. Tess Marquez, on a mobile home, if a park is evicting him, home, long can they stay if the occupant's getting relocation if he refuses to leave? Well, a eviction takes about 3 to 4 months. So the average time frame will be 3 to 4 months. Christina, what if it's a new lease agreement in Orange County? Christina, if the right exemption was issued, then you're exempt. If I've seen a lot of agents use their car forms, and they are updated forms, but they don't mark the exemption. So sadly, and with a crushed heart, I have to tell them that although they have the right agreement, they did not exercise their exemption. As such, they're still under regulations. So if you know how to fill out your agreement correctly and you check off all the right boxes, you may be exempt. In order to verify, you could always email our team. We could do a consulting appointment and verify that you're on the right track.
Thank you.
Not a problem. Yuling Hung, if there is never a lease agreement, can the landlord evict the tenant? The tenant did not pay rent every month. So
They did pay rent.
whether there's a rental agreement or not, the protections do not change. So the tenant still has the same rights, the same protections. It would have to, once again, there's no answer to this because I have no background, no anything. I need to do a proper consulting appointment in order to answer that question. Okay, Hung?
Okay, thank you.
Not a problem.
Hey, Paulina.
Yes.
Yeah, question. We're talking about all those landlords that they cannot collect rent because the tenants has moratoriums and they get extended. So they don't get any rent. So talking about the landlords. So all those people are not collecting rent. Basically, they lose the whole, let's say for a year or so, they cannot get any money back from the tenant. When they start again, they start fresh from zero, right?
So no, Michael, at the beginning of the presentation, I did mention that all those evictions are on the table. So as long as the rent relief either denied them or it's inactive. So the rent is not forgiven. You could go after it, whether it's an eviction or small claims. So no, they don't start at zero unless rent relief paid.
Okay.
Tyrone, I'm unsure of your question. I don't know if you want to unmute yourself and ask me.
Yeah, I'm just wondering, those basic fees that you mentioned, is that for an agent who wants to be a member, or if you represent a seller and they need help, that's the fees for the seller?
For any customer that desires our services. Yes. Thank you.
Okay.
Thank you. If a relative did a lease agreement and he's not the owner, can the administrator evict the tenant? Why, my question to Tess is, why did they do a lease agreement?
Well, the relative did a lease agreement without having to let known by the administrator that they did the lease agreement so far. So
how did they have access to the property in order to do that?
I'm sorry? What was
How
that?
did they have access to the property in order to go in and rent it?
Well, they pretended that they were the owner because he is the son. He's the son of the owner, but then the son, the mother already is deceased.
So who is the executor of the trust? Who's in charge?
It's the sister who is in charge.
Okay. How long has that person been living there? The tenant?
They're all tenant occupied. It's the brother who did the lease agreement to the tenants, which he is not the owner, and now the mother passed away, so that the sister who is now appointed as the administrator wants to sell the property, but they don't know if it's worth it to evict the tenant, or they're trying to
Yeah.
ask if they can evict.
The question really comes down to how long has the tenant been living there? If it's not a couple of months, you can't get away with saying, oh, I did not know.
And they've been there for almost about, I think, 6 years.
Yeah, no, they're tenants.
Yeah,
You cannot ask to evict. And it depends on the scenario, if you could ask to evict and the reasons why.
got it. Okay. Thank you.
Okay, it's 101. Cindy, I don't know if you want me to pick up one last question.
Yeah, let's do one more and then we'll call it a day, and, you know, and maybe put up your numbers again, and yeah.
Yeah, let me go ahead and change.
I have a scenario and a question that I wanted to follow up with.
Okay.
This property is in a trust. Actually, the owner had dementia and since then passed. Now the son, who is the trustee, is taking over. They had a tenant who's been there, you know, long time, minimum 6 years. So what the trustee did, actually, they sent the tenant a note stating that they were getting ready to put the dad in a facility, and they would need to sell the properties to cover the expenses. Very amicable, and gave the tenant 60 days, and the tenant was very responsive and ended up actually finding another place and moving out even before the 60 days. Is that the end of the story, or is there anything else that needs to be done?
If the tenant already vacated, it seems like that's the end of the story.
Okay.
Unless there was a misstep and then the tenant finds out and they decide to do a suit for wrongful eviction. But it sounds to me like the tenant may not come back.
Yeah. Okay. Okay. They have everything documented. I was not involved with it, but they have everything documented in an email and going back and forth. And it was just a friendly way of parting ways.
Yeah, I mean, luckily there is, I always say these rules are in place for tenants that don't behave, because the tenants that do behave, even if the landlord is doing something illegal, the tenant will move out because they're scared or they don't know how to deal with it. The landlord is really in trouble when they're dealing with an experienced tenant or when a tenant gets informed. And I mean, unfortunately, this is the other end of the pendulum. This is the reason why rent control was created, to offer protections from tenants being evicted in short notice or improperly or without relocation. And, you know, this is the reason why one size does not fit all. Good question. I do know we do not support to help tenants. They have enough free help. We are the landlord's ally, so we only service landlords, okay? And I must be clear, we're not a free service because we don't get funded by the government. And in order to keep my doors open and people answering phones, I do need to charge, and I do have to let you guys know this up front, because we get a lot of calls if we do free consulting appointments, and we cannot sustain out of free consulting appointments anymore, especially with the law changing. There's no one answer. We really need at least half an hour to get to the meat and grit of what's a solution for your scenario and what are your options in order to protect yourself and your client, whether you are representing the buyer or the seller. So make sure that you are being diligent, that you are informing yourself and informing your client, because, you know, we could only get lucky for so long. And I see that happening a lot lately with these rules, these changes. So with that, you do have my information on the chat. You guys could screenshot that. I hope this you did learn a thing or two from this webinar and picked up new tools and resources for you and your clients.
Thank you so much. Can everyone
Thank you.
unmute themselves? And
Yes, thank you.
Everybody unmute, please. Give her the respect she deserves. Thank
Yes.
you.
Thank you.
Paulina.
Thank you.
Thank you.
Thank you, Cindy, for setting this up.
Thank you.
Thank you, Cindy.
This
Okay,
was
team, well,
fantastic.
have a great rest of your week.
I'll be